seminar on debating the human rights violations and war crimes in Indian illegally occupied Jammu and Kashmir, including the Russell Tribunal 2021's proceedings. We will commence proceedings of today's seminar with recitation from verses of the Holy Quran. On an extremely important subject. Organized by the Kashmir Civitas in collaboration with various NGOs and civil society organizations, the first Russell Tribunal on Kashmir comprised 15 international judges, all experts from the global legal and academic community. 4 sessions on the themes of genocide, settler colonialism, crimes against humanity, and decolonization, in addition to the opening and closing ceremonies, were held between the 17th and 19th of December 2021. To discuss the contribution of the Russell Tribunal on highlighting both the gross political, social, and legal injustices in Indian illegally occupied Jammu and Kashmir and the importance of international law in countering them, we have 5 distinguished speakers on the panel today. Following the keynote address and presentations made by our respective speakers will be a question and answer session. Following the question and answer session, I would request the chair to sum up the discourse from the seminar. Ladies and gentlemen, it is my honor to introduce the panel to our audience. The chair for today's seminar is Ambassador Inamul Haq. Ambassador Inam is a Pakistani career diplomat who previously served as the Foreign Minister of Pakistan and the Foreign Secretary from February 2000 to June 2002. Ambassador Inam has served as Pakistan's ambassador to Turkey, China, and permanent representative to the United Nations. The keynote address will be delivered by Mr. Ahmed Bilal Sufi. Mr. Sufi is an advocate of the Supreme Court, the president of the Research Society of International Law, and senior managing partner of ABS & Co. He previously served as a federal minister for law, justice, and parliamentary affairs, and is a member of the panel of eminent persons of OIC. Additionally, he has served as the chairman of the UN Advisory Committee on Human Rights in Geneva. Following Mr. Ahmed Bilal Sufi is Dr. Farhan Mujahid Chak. Dr. Farhan Mujahid Chak is the Secretary General of the Canadian-based NGO Kashmir Civitas. He serves as an Associate Professor of Political Science at the Gulf Studies Graduate Program at Qatar University. He has worked at the United Nations, the Canadian Parliament, and Prince Al Walid bin Talal's Center for Muslim-Christian Understanding at Georgetown University. Dr. Farhan will be joining us virtually on Zoom. Our second speaker for the seminar is Dr. Raja Kasir Ahmed. Dr. Ahmed is Registrar and Assistant Professor at School of Politics and International Relations at Quaid-e-Azam University, Islamabad. He previously served as a research scholar at Columbia University in 2018 and research associate at the University of Nottingham in 2017. He has authored 2 books titled Democracy and Political Change in Pakistan and Democracy in Pakistan from Rhetoric to Reality. Our final speaker for the seminar is Mr. Hassan Shah. He is a legal director at CMS McKenna Oman, a leading Middle Eastern law firm. He graduated from the Harvard Law School with a focus on international law and is the first Pakistani to intern at the Office of the President of the International Criminal Court, The Hague. Mr. Hassan Aslam Shah also joins us via Zoom from Oman. I would now request Acting President IPRI, Brigadier Rashid Wali Janjua, for his welcoming remarks. Sir.
Ambassador Inam, Chairman BOG IPRI, the chair of today's seminar. Mr. Amr Bilal Sufi, the keynote speaker of today's seminar. Dr. Farhan Mujahid Chak, Secretary General, Kashmir Civitas, and Dr. Raja Kasir. Welcome. I also extend a very warm welcome to a distinguished audience. This is an attempt today to showcase the atrocities in Kashmir, which span a wide gamut of human rights violations, crimes against humanity, and war crimes. The Indian human rights violations, erasure of Kashmiri identity, and trampling of international law has gained maximum traction under the current BJP regime, led by a Hindutva votary like Narendra Modi. The illegal annexation of Kashmir after revocation of Article 370 in 2019 has resulted in the reinvigoration of Kashmiri freedom movement, which since last 2 years has been subjected to all kinds of pressures, including incarcerations, mob lynchings, killings, alteration of demographic balance, violation of property rights of the state subjects, and a digital apartheid through communication blackout. The international community, despite being aware of the illegality of Indian annexation of the state of Jammu and Kashmir and egregious human rights violations, looks the other way because of the Indian influence with the global powers. It is an unfolding tragedy that features a melange of crimes against humanity, genocide, and war crimes, each of these requiring a separate treatment on humanitarian and legal fronts. It is therefore the collective responsibility of international community, including advocacy groups and human rights NGOs, to highlight the Indian atrocities and be the voice of the persecuted Kashmiris. We have amongst us today a galaxy of international law experts as well as advocacy group members who can throw light on human rights violations, crimes against humanity, and genocide in Kashmir. And I'm especially very glad to have amongst us the moving spirit behind the international law response of Pakistan to not only Kashmir, but other causes as well. That is Mr. Amr Bilal Sufi. And let me confess at the outset that he's been the moving spirit behind IPRI's special efforts to highlight the role of international law in not only Kashmir advocacy, but other issues that confront Pakistan. And he has been a founder member of the only research think tank in Pakistan which deals with international law. And this is an aspect that needs a lot of attention, not only by policymakers, by academics and the civil society as well. And I'm very happy that today the whole panoply of human rights violations, crimes against humanity, genocide, so each one of these terms has special connotations, and it means something different to a layman and also to the experts. And each in its turn contains a menu of response options that I'm very glad to note that amongst the RSIL research advocacy, a lot has been written on that score. And now there are international NGOs like Civitas, which under a very dynamic Secretary General, whom would be privileged to listen to, Mr. Farhan Chak, who is a Kashmiri himself, and they are doing a great job highlighting the war crimes, highlighting the international, dimensions of Kashmir issue, and including the danger of a nuclear conflagration. A Russell Tribunal, which was held, 15 to 18 December, it showcased all those, human rights violations and, the atrocities that are being committed against the Kashmiris. And these advocacy groups are going to be the voice of Kashmiris. And we knew how a similar Russell Tribunal, it changed the whole narrative on Vietnam. And the world started viewing the Vietnam problem from a different prism after a series of such advocacy meetings. And I'm positive that the Kashmir issue, which because of the global geopolitics is not getting much attention, would also get a lot of attention from those who, for the time being, may have averted their gaze from this very important subject. So with these few words, I would like to welcome the keynote speaker, Mr. Amr Bilal Sufi, to come and deliver his talk to us.
Bismillahirrahmanirrahim. Honorable Ambassador Inam Saab, Honorable Brigadier Wali Saab, other panelists, guests, ladies and gentlemen, Assalamu alaikum. I'm really grateful for very kind words for the work of RSIL that we have been putting in for last 3 decades on various aspects of international law. The Ministry of Foreign Affairs and the government of Pakistan has been politically keeping the issue alive for last so many years. Despite opposition from the Indian side, despite opposition from various stakeholders at a global level, we noticed that the issue of Kashmir has not died down. But there is a legal dimension to it. And the legal dimension is what can we do from an international law point of view, since this discipline also offers multiple forums, opportunities, and a very structured way to advance your causes. We notice that international law, state practice is a very important aspect. What do states do continuously over a period of time? So the state's practice of Pakistan relating to Kashmir needs to be documented at various levels. The matrix as to what can be done has now been brought under the broad rubric of lawfare, something that we now hear where the government, the establishment, the civil society is talking about it as a neon sign for developing legal strategies relating to various aspects, including that of Kashmir. In today's session, I will give you an overview of the Russell Tribunal and at the same time, see where do we go from here as the state of Pakistan? Do we have similar options or not? So may I request the first slide, please? Slide dikhaiega, next wali. Lawfare on Kashmir, next please. We have the option of exploring approaching international forums. Multiple forums are available. And in terms of numbers, we have thousands of forums, legally speaking, that exist where the matter, not holistically, but partially various aspects of that can be brought to the notice of that. People keep on asking, is there a holistic forum where the entire issue of Kashmir can be taken? Not exactly, except United Nations, except UN Security Council, except UN General Assembly, except UN Secretary General's office. These are the forums which can holistically take notice of the entire issue of Kashmir. But the issue of Kashmir now has so many dimensions to it that it actually is also an opportunity to push those dimensions at various forums. So various forums could be made use of. Next, please. Presenting the case of Kashmir and Kashmiris. The word case is important. Normally, people tend to suggest that case of Kashmiri means as if we have to file in some formal court. एक सिविल कोर्ट में हमने दावा फाइल करना है, किसी ग्लोबल सुप्रीम कोर्ट में हमने लेके जाना है, कहाँ फाइल करें, एक एंजाइटी होती है. Which forum is open for us? The case people assume means a formal case, the way you have a litigation section in any corporate entity. No, I don't mean that. I mean presenting a case means presenting it in any diplomatic forum, in the speech by the Prime Minister, in the speech by the official representative of Pakistan in UN, in a formulation by the Ministry of Foreign Affairs official website. That's presentation of a case, presentation of your view, position on various aspects of Kashmir. Presentation by an NGO of Pakistan abroad, presenting the version of facts by an accredited NGO in ECOSOC. So Pakistani NGO could make an effort to develop an accreditation, and through that, it has a right of audience in all UN forums, whether it's ECOSOC, whether it's Human Rights Committee, whether it's any other forum. So presenting a case means developing a narrative and making it legally plausible. Legally plausible is important because you may not have picture-perfect argument to support your version. There will be a counter-argument, there will be a counter-narrative. But the important thing is, can your argument be viewed as prima facie reasonably good? In case of Kashmir, obviously we have far superior strength in terms of legal depth of the argument that we are talking. Lawyers are able to find ways to defend far weaker cases in courts and in forums. This is far more stronger case. Now, setting up of ad hoc tribunals is one of the strategies of lawfare, because the ad hoc tribunals can thrash legal aspects, can thrash evidence, can go into individual cases, can collect affidavits, can identify specific features that normally, in terms of foreign policy framework, you may not want to focus, but legally it becomes important because gradually that building blocks, they had become building blocks to a larger narrative. So ad hoc tribunals are extremely crucial. Even if it is not an ad hoc tribunal, it could be an initiative from within the country. And we'll talk about that. Next, please. Approaching global think tanks and co-sponsoring Kashmir work is also should be part of the strategy. You see, there's an official way to support Kashmiri financially. There's an official way. If you are registered as a person who represents a certain cause in US under US law, then you have open and a fair authorization to plead that cause, to be an advocate of that cause. If you recall, Dr. Ghulam Nabi Fai was not registered initially, so he had to suffer a legal situation, but then he was registered after 2 years. And by virtue of that, he could accept donations. He could accept funding simply because he was compliant of the law relating to foreign agents regime. So there's an official methodology to pour in money to sponsor Kashmir-based academic initiatives. Then you have obviously a flexibility to sponsor chairs in think tanks, in global think tanks. That is something that has not been looked into very strongly, but a sponsoring of a periodic chair on international law at various think tanks is perfectly doable, and think tanks welcome that as long as you put the money. I remember about a decade ago, I went to Brookings and I was told that Reliance is sponsoring a chair, and such is sponsoring us. So I told her that why don't you have somebody from Pakistan? And he opened the door and said, look, these are the requests of money that has been committed to me by various Indian business groups. So if you bring in a group or Pakistani group approaches, we are prepared. So therefore, there should be a very informed, strategic way of sponsoring scholars, sponsoring chairs, just like Middle Eastern government sponsors specific chairs in Harvard, at Yale, and so on and so forth. So why can't Pakistan think on the same lines and talk to the Harvard or to the Yale or to Stanford University and so on and so forth? Next, please. Reaching out to international legal bodies like American Society of International Law, International Bar Association. Ladies and gentlemen, there is what we call a legal grid of lawyers. They graduate, they interface at the time when they're at law schools, then they 10 years on, they're all at various places in different countries, and then they become part of bar associations. And they have common issues to think, thrash, debate, have a dialogue at professional forums. Now that legal grid becomes an asset if you were to wire in your narrative into that. And most of the time, they look at current contemporary issues. So the same legal advisor who has 20, 35 years of experience in a ministry of Norway, or a ministry of UAE, a ministry of India, a ministry of Pakistan, could be found positioned in IIOJK legal division another 5 years on. He could be found positioned in UN Secretary General's legal team. So the legal grid approach is also very significant. That if you are able to, allocate sessions in International Bar Association on theme rather than the concept, they will not have Kashmir, but they will have something on self-determination. They will agree on something on unilateralism. They'll have something relating to R2P, responsibility to protect. And in that, you tuck in the case study relating to Kashmir. This is not the appropriate time to have. So what I'm saying is there is so much of innovation that is possible in terms of developing a wholesome strategy. Next, please. And then, of course, is a diplomatic and legal offensive, for example, submitting of the dossier and so on and so forth. The dossier should also contain possibly, I do not know what, the legal narrative relating to that as well. So while you talk about the facts, you also have to develop a presentation on the legal side, explaining how these facts help violate clearly on record the legal provisions. Next. So now coming to the Russell Tribunal, it was a private tribunal. This is important. In other words, there is no obligation that you must establish a global court. Yes, it is not binding in nature, but it's a initiative by Bertrand Russell, a very famous historian and a thinker and a political philosopher, who felt aggrieved, and by Jean-Paul Sartre, the famous French philosopher again, who thought that what has happened in Vietnam is such a gross violation of international law, international norms, notwithstanding the diplomatic and foreign policy compulsion that Americans wanted to be there. But even if they were there, it led to a serious violation, and that violation cannot be allowed to be passed unaddressed. Therefore, this tribunal was established as a call of conscience, private initiative. The foundation of Bertrand Russell established this, and then it continued to have its own momentum. It kind of was de-emphasized over the last 10, 15 years, and I'm glad that our colleague from Canada, they were able to, kickstart and line up their work with reference to this Russell Tribunal. Next, please. So it's called International War Crimes Tribunal. Next, please. Russell himself was a man who was masterminding the tribunal, and he relied on Robert Jackson, who was then the chief prosecutor of the Nuremberg war crimes trials. Next, please. In which he said, if certain acts and violations of treaties are crimes, they are crimes whether the US does them or whether Germany does them. We are not prepared to lay down a rule of criminal conduct against others, which we would not be willing to have invoked against us. So please concentrate on the first line. If certain acts and violations of treaties are crimes, they are crimes. Meaning, notwithstanding, that's a legal formulation. If someone is committing a violation and violation is self-evident, then that needs to be presented. That needs to be argued like that. One need not to be apologetic about it. It's a gross violation. Next, please. And then it was this tribunal which kick-started that wave of consciousness that something needs to be done. And eventually, in 90s, we had the International Criminal Court established. Next, please. The tribunal aims were that it included multiple academics, scientists, lawyers, and former heads of states who participated in this. आगे चले. अब उन्होंने जो questions frame के लिए अपने लिए वो कौन से वाले थे? Next. अब इस question को compare it whether can you have this question for Kashmir. So the question is, has the US and the governments of Australia, New Zealand, and South Korea committed acts of aggression according to international law? बड़ा crucial question था. जो कश्मीर पर hearing हुई उसमें ये question नहीं है, but वियतनाम में ये question था कि aggression है कि नहीं है. So the way you frame the question gives you the right answer as well. This was much more holistic, much more grave, and much more serious in nature to give us a finding if they, as a state, has committed an act of aggression. So it's not state's instrumentality like an army brigadier or somebody doing. State, US has violated or not, an act of aggression hua hai. Aggression is again a very technical legal term in international law, that if you're violating the UN Charter in addition to some other violations, then you are committing an act of aggression. This is not exactly formed in case of Kashmir, but nevertheless. Aage. Has American Army made use of experimented with new weapons or weapons forbidden by laws of war? There are categories of weapons that are, if they are indiscriminate in nature, if they result in unnecessary injury, they are prohibited under international law relating to humanitarian area. Meaning thereby, you cannot use weapons that create unnecessary suffering. If there's a compulsion of war and you want to kill people and you have legitimate cause for that, then you have to use weapons whereby the objective is achieved promptly rather than lingering the suffering. And in that sense, certain weapons are clearly in a prohibited zone under international law. We noticed that when in the context of Kashmiris, I recall that Pakistan wrote a note to Italian manufacturers and Italian government when the government of India was making an effort to import snipers on the pretext that this nature of weapon is such that it violates international humanitarian law, and the government of Italy paused. Next, please. Has there been bombardment of targets of a purely civilian character, for example, hospitals, schools, dams, and on what scale has this occurred? Very crucial. And since we are studying international humanitarian law, so Indian lawyers are also advising their army, the JAG branch of Indian Army. There's an Indian Society of International Law, which is working in the last 1950s, and they have a premises next to Supreme Court of India. And they have been regularly generating human resource to advise the government of India. They are also very well wired and well connected with ICRC as well to get sense of where do we come from. So their target selection in the recent 5 or 7 years has become much better in terms of attracting violation. So the condemnation on a target selection, there have been few gross violations, like you tie up someone with a bumper of the Jeep and circulate him, it's a gross violation, and so on and so forth. But they have built the argument that even if they have attacked the civilian targets, it is because it has been misused by the terrorist and so on and so forth. Next, please. Have Vietnamese prisoners been subjected to inhuman treatment? So if you are retaining people in custody or denying them fundamental rights, right of movement, right of interaction with the family, right of lack of whereabouts, and so on and so forth, that is also a violation of international law. In case of Vietnam and also in case of Kashmir, we visibly note that. Aage chaliye, next slide. Labor camps was a specific thing in their condition, but has there been deportation of the population? Ye note kijiye. Deportation from the venue of conflict is a violation of Geneva Convention. You cannot deport people. You cannot alter the status quo structure if you are an occupying army. So if you are occupying force, pehla, you have to first establish that you are an occupying army. If you are an occupying army, then occupying army has restrictions. Cannot change the currency, cannot deport people, cannot change the demography, and so on and so forth. इसलिए हमारा ये argument पाकिस्तान का रहा है कि Article 35A of the Indian Constitution, जिसको उन्होंने अब neutralize किया है, that effectively is the Geneva Convention miniature version, which said that, you will not be allowed to take and buy property in this area, जो अब उन्होंने reverse कर दिया ताकि demographic structure को change किया जाए. So ये concern deportation पर is linked with international law. Next, please. So what were the findings? अभी आप ये तस्वीर देखें कि एविडेंस कि ट्रिब्यूनल काम कैसे करता है कि एक बच्चा है, उसको ट्रिब्यूनल के मेंबर्स डायरेक्टली एग्जामिन कर रहे हैं फर्स्ट हैंड, प्राइमरी एविडेंस जिसे हम कहते हैं, कि उसको गौर कर रहे हैं, उससे बात कर रहे हैं, उसको मेडिकली इवैल्यूएट कर रहे हैं. दिस इज द काइंड ऑफ एविडेंस दैट इज रिक्वायर्ड, जो यूएन की कुछ रिपोर्ट्स में आई भी है. मगर दिस इज द नेचर ऑफ अ ट्रिब्यूनल, जिससे फिर मोमेंटम बनता है फॉरेन अफेयर्स का और फॉरेन रिलेशंस के डिप्लोमेटिक उसका, कि once this is documented that we examined such and such, as much as we read from the net that इसमें भी एक या दो अभी witness आए थे, but we don't know कि और evidence अभी इस रसल ट्रिब्यूनल में पेश होगी कि नहीं. So evidence is very crucial. please understand, arguments have to support the evidence. Both have to coexist. There has to be a specific instance identified. वो हम evidence कहलाएंगे. और फिर उस पर narrative आएगा, ये violation of international law, ये violation of domestic law, ये Indian law की violation, Pakistani law की violation, ICCPR की violation. But first the fact, broad brush taking that they are violating human rights is not immediately recognized. It's not immediately accepted. Next. अब यहाँ पर उन्होंने गवर्नमेंट्स को रिस्पॉन्सिबल करार दे दिया इस ट्रिब्यूनल की फाइंडिंग में. उन्होंने कहा ये चारों गवर्नमेंट्स रिस्पॉन्सिबल थी because they committed acts of aggressions under international law. Serious charge, very serious charge, which was a conclusion. Next, please. Governments of Japan, Thailand, and Philippines are guilty of complicity in the aggression committed by United States. So if someone is not helping or preventing someone to help, then you are complicit in the act of aggression. So if you are saying that you have an R2P framework and people are preventing you from assisting the Kashmiris, then could we argue that this is a situation of complicity or not is a question mark. And if you say it in generic sense, you are complicit because you're not helping Kashmiris, I mean, to the world community, that's one way. But if you say in situation of this nature where you stay quiet and where they deserve help to be rescued from a potential genocide, if you don't do that, then you are technically complicit in the international law. Is, you know, the strength, the weight of the said statement increases manifold. Okay. The government of US is guilty of deliberate, systematic, and large-scale targeting of civilian targets and populations. Serious, very serious charge. The state. If you remember, Nicaragua matter में जो 1986 का judgment था ICJ का, उसमें this link, when is the state responsible and when is the state not responsible was identified. And they came to a conclusion that unless there is specific authorization, for example, हमारे जो लोग गए हुए थे उनके बारे में कितना तक हम रिस्पॉन्सिबल हैं. एक शख्स जो हमारी मर्जी के बगैर कोई काम इररिस्पॉन्सिबल एक्ट दूसरे मुल्क में करता है, क्या उसके लिए पूरा मुल्क रिस्पॉन्सिबल होगा? जो हमारे खिलाफ नैरेटिव पाकिस्तान के खिलाफ बना वो यही बनाना कि हाफिज सईद और मिस्टर एक्स और मिस्टर वाई और मिस्टर जेड जो हैं वो ये कर रहे हैं, लिहाजा पाकिस्तान रिस्पॉन्सिबल है. एक इंडिविजुअल एक्ट है जिसको लिंक नहीं किया जा सका लीगली विद द स्टेट ऑफ पाकिस्तान. सो व्हेन दैट लिंक इज स्नैप्ड, so it's at best an irresponsible act of a national abroad. So nationality cannot be the basis of responsibility. So ये बहुत state responsibility की जो principles हैं उसमें बहुत इस पे काम किया गया है. और इसकी state responsibility क्या कि why should the state of Pakistan be burdened for an irresponsible act of a non-state actor? Why a state of Pakistan should be held responsible for someone who's notified in a 1267 list of Taliban associate? Why should I be responsible as a state of Pakistan? यहाँ पर state को responsible declare किया जा रहा है. So the evidence was overwhelming. State है, इन्होंने किया. इनकी various war orders थे, attack this, attack that, वो सब orders document करने के बाद they had come to this conclusion. Next please. और उसमें जो advantage पाकिस्तान को है इस वक्त against India वो ये है कि India की ownership है of these illegal acts. Something जो इस tribunal को effort करना पड़ा prove करने के लिए, या जो आपके खिलाफ एफर्ट होता आया मगर प्रूव नहीं हो सका, लेकिन वो पॉलिटिकली मिलाइनिंग आपको इतनी कर दी गई कि ये प्रिज्यूम कर लिया गया कि पाकिस्तान ने सारे जो कराता है इस रीजन में पाकिस्तान की हुकूमत कराती है, चाहे अफगानिस्तान है, कश्मीर है, इंडिया है, कोई धमाका, कोई ISI गवर्नमेंट ऑफ पाकिस्तान सारा ये करा रहा है. बट वेयर एज वहां पर जो है वहां पर ओनरशिप जो है उसको आइडेंटिफाई करना बड़ा स्पेसिफिक लीगल रिक्वायरमेंट्स है. सो उस कॉन्टेक्स्ट में इफ यू लुक एट इट तो यू विल नोटिस दैट इन केस ऑफ वेरियस इवेंट्स जो अब खास तौर पर हो रहे हैं कि पाकिस्तान को आप रिस्पॉन्सिबल नहीं करार दे सकते. दैट इज व्हाट पाकिस्तान शुड बी आर्ग्यूइंग. इंडिया ऑन द अदर हैंड ने जो 5 अगस्त 2019 का प्रेसिडेंशियल ऑर्डर इशू कर दिया है, उसने ओनरशिप ले ली है ऑफ द इलीगैलिटी. That's a legal link of the illegality. Please appreciate this. It's a very, very serious thing from an international law point of view. The state takes the ownership. The state, through a legislative instrument, says, this is my place. Not only this, but what is on the Pakistani side is also mine. So this illegality need not even be proved. Well, latin maxima less ipsa liquitor. Let the thing speak for itself. Proof खुद ही बोल रहा है, मगर वो इतना ज्यादा क्लियरली बोल रहा है कि हमें भी obvious, जिसे हम कहते हैं ना, लॉ में एक टर्म है, obvious is often overlooked. ये proof इतना like a neon sign is staring in our face and we're not registering it. कि illegality की ownership रियासत का legislative instrument document कर रहा है, जो मुझे proof करने की तरद्दुद नहीं करना. आगे चलें. Is guilty. Next, please. Next. Outcomes. So obviously it was not a government body or official tribunal. So उसकी legal authority उस तरह से implementable framework में नहीं थी. Next. Idea was to raise awareness about the impact of war. Next. It started a political movement against anti-war. Next. उसके बाद, it self-searching की एक effort और बहुत कुछ लिखा जाने लगा against a war. Next, please. So it led to a legacy of another thing जिसको हम कहते हैं People's Tribunal, कि लोग खुद भी tribunal establish बना कर सकते हैं, और वो फिर आहिस्ता आहिस्ता सामने आना शुरू हुआ. Next. आगे. उसके बाद next please. Next. So Russell Tribunal लैटिन अमेरिका पर उसका एक बेंच बैठा. ट्रिब्यूनल से मेरी मुराद ये है कि ये लोग एडहॉक बेस पर, so the Russell Foundation acts as the secretariat. It convenes a group of experts on a given day or few weeks or whatever, based on the sanction from the board of directors, and they then conduct informed hearings in respect of a certain issue. अब वो issue कौन-कौन से थे लैटिन अमेरिका 1974-76 का, जिसपे उन्होंने ब्राजील की ह्यूमन राइट्स वायलेशन पर फोकस किया. फिर इसी तरह साइकेट्री. नेक्स्ट. नेक्स्ट बिकॉज ब्रसल इराक के ऊपर बैठा ऑन द एलिज्ड कैंपेन ऑफ वायलेंस अगेंस्ट इराक, उसको उन्होंने एग्जामिन किया. नेक्स्ट. और फिर पैलेस्टाइन के ऊपर they sat as a group of experts commissioned by the board of directors of the Russell Foundation, and they looked into various aspects. Next. ये जो साहब हैं, इनका नाम है प्रोफेसर शरीफ बिस्यानी. फौत हो गए. शिकागो लॉ स्कूल के बड़े renowned प्रोफेसर, इंटरनेशनल लॉयर हैं, and he was part of the panel of experts. We were 4 international lawyers selected from the Muslim world. He was one of them. I was there. There were a couple more. एक बांग्लादेश से डॉक्टर, वो फेमस हमारे जो जिन्होंने वो prisoners agreement भी sign off किया, very aged now, का नाम अभी वो थे. Sharif Bisyani was appointed as an investigator of Bosnia war crimes, and I remember going to his office in Chicago. So he took me. इस कमरे से इनके साथ लेफ्ट साइड पे कमरा था जिस पर उन्होंने वॉर रूम लिखा हुआ था. वॉर रूम के अंदर पूरा मैप्स थे रनिंग ऑन द वॉल्स ऑफ बॉस्निया, जिसमें मैस ग्रेव्स आइडेंटिफाइड थे, एट्रोसिटीज की वेन्यूज आइडेंटिफाइड थे. एंड देन ही हैड विजिटेड 2 or 3 टाइम्स. एफिडेविट्स का स्टैक पड़ा हुआ था, खवातीन का, बच्चों का, तस्वीरें, व्हिच ही वाज टू सबमिट. वो जो विजुअल मेरे जहन में बैठा तो मुझे रियलाइज हुआ कि अगर हमने किसी इशू पर सीरियस काम करना है तो उसके लिए एक रिसोर्स मैनेजमेंट का कॉन्सेप्ट है. वो आप किसी यंग लॉयर को या मुझसे एक बिलाल साहब आप एक डॉक्यूमेंट बना दें, इस पे हम कुछ करना चाहते हैं, किसी और को इस तरह से नहीं होगा. वो हो जाएगा, कुछ ना कुछ कर लेंगे. लेकिन इफ यू वांट टू डू अ होलसम थिंग, then that image stuck with me, that you have to devote resources, devote space, raise a team, and then live with that proposition for months, day in and day out. You cannot do it on a conference to conference basis. You cannot do it on an event के conference कर ली, उस पे पेपर पढ़े 5-6 उनको इकट्ठा किया, इस तरह से नहीं. It has to be a very serious undertaking. You're attacking another state. So this was something that stuck with my mind. Next, please. फिर ये परमानेंट ट्रिब्यूनल इटली में एस्टैब्लिश हो गया. वहां पे एक सेनेटर साहब थे, उन्होंने कहा मैं फंड देता हूँ, इसको एस्टैब्लिश कर देते हैं. और उसके बाद मुख्तलिफ इसके सेशंस हुए. नेक्स्ट. म्यांमार पे हुआ, कश्मीर पर फिर अब ये वाला. नेक्स्ट प्लीज. सो ये इवेंट का कार्ड है जिस पर ज्यादा बेहतर मेरा ख्याल है माय कॉलीग फ्रॉम कनाडा विल एक्सप्लेन, बट organized by them, and then it had 3-day session as per the card information, which is a good beginning, but it needs to be many more hearings. considering the nature of the quantum of evidence that is available on Kashmir from even objective sources. Videos hai, evidence hai, people are prepared to talk, they are prepared to give testimony on Zoom, they are prepared to execute affidavits, and so on and so forth. Next, please. So उसमें उन्होंने 15 international lawyers, judges and prominent personalities को invoke ले आगे चले चलते जाइए आगे 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 आगे. So ये पहला session हुआ. We are not exactly aware because the जो इसकी website है ट्रिब्यूनल की उस पर बहुत ज्यादा तफसीलात मालूम नहीं हो पा रही कि अब next session इसका कब due होगा. Next. So the first session had themes, important themes. Genocide के occurrence क्या हुआ, genocide, decolonization के context में उन्होंने इसको terms को frame किया और crimes against humanity. So legality of issue को पीछे करके इन्होंने जो actual events हैं, violations हैं, gross violation, उन पर focus किया. Next. The judges, उनकी जो initial statement थी वो यही थी कि they intend to hold further sessions. They called upon the world public to visit Kashmir and report on the state of freedoms, called upon United Nations to properly oversee decolonization process. And this basically are saying कि decolonization के agenda का extension है, तो please perform your obligations. Called upon UN to request an advisory opinion of the ICJ on this, and then other facts. Next slide. So this is, I'll just emphasize on the first line, fact Kashmir is a disputed territory. To me, this is the crucial finding of informed 15 people coming all over the world. It's not an issue that India argues that cannot be raised further. It's been settled by state practice. Humne apna le liya, aapke paas aapka hai, so on and so forth. No, they say it is a disputed territory and the dispute lingers on and dispute has to be handled and managed. Aage chale. Following the Kashmir is not a secessionist movement. That's also very crucial because there's a very thin line between a secessionist movement and a freedom fighters. Penal Code of India, Penal Code of Pakistan में secessionist movement के खिलाफ आप FIR दर्ज कर सकते हैं. Anyone who wants to break the country will be viewed as a secessionist. तो कब वो फ्रीडम फाइटर्स के दर्जे पे फाइज हो जाएगा कि सेक्सेशन मूवमेंट के उससे बाहर निकल जाएगा? इट्स अ वेरी इंपॉर्टेंट क्वेश्चन एंड इन द कॉन्टेक्स्ट ऑफ पाकिस्तान अगेन वेरी इंपॉर्टेंट बिकॉज आपके पास कुछ सेक्सेशन मूवमेंट्स के खदोखाल मौजूद हैं. सो क्या ये आर्गुमेंट उनको स्ट्रेंथन करता है या डिस्टिंग्विश कर पाता है इज अ क्वेश्चन मार्क. आगे चलें. Among the most heavily militarized, the presence of the army reaffirmed by the tribunal, the number and the scale makes it an occupying territory, makes it a situation of a international armed conflict. India इसको कहे कि law and order situation है, terrorist तक confined है, but Pakistan का view कि international humanitarian law की violation है, and this view is shared by all international global think tanks कि it's a international humanitarian law situation. आगे चलिए. 14 जून को फिर ये दो important reports थी. Next please. जो 14 जून 2018 को आई और फिर 2019 में आई यूएन हाई कमिश्नर की, दे आर कंसिडरेबली मच बेटर डॉक्यूमेंटेड. सो ईच ऑफ दैट केस इज क्रूशल इन टर्म्स ऑफ व्हाट इट आइडेंटिफाइज. उसमें कुछ में एफआईआर दर्ज हुई हैं, कुछ वैसे ही रिकॉर्डेड हैं. सो ये क्वेश्चन मार्क है वेदर वी नीड टू प्रोसीड ऑन दोस. नेक्स्ट प्लीज. फॉर एग्जांपल एक मेजर जो है यासीन मलिक साहब का अपना केस, जो पहले गवर्नमेंट ने उनको कहा था, वादा किया कि हम ये खत्म कर देंगे और आप मेन स्ट्रीम में आ जाएं, एक्टिविज्म छोड़ दें 10-15 साल पहले, उन केसेस को रिवाइव कर दिया. सो नाउ इफ यू वर टू कंटेस्ट दैट केसेस कि नो ही इज अ फ्रीडम फाइटर, इट्स नॉट अ सेसेशनिस्ट, सो द केसेस अगेंस्ट हिम आर मोर प्रिडोमिनेंटली ऑफ टेररिज्म एंड ऑफ दैट. सो इफ his wife is given legal support to argue before the relevant forums, to get a lawyer and to argue before the relevant forum that no, this is actually he's not a terrorist for these reasons, and if there has been an act of terrorism attributable to him, then he has the legitimate right to use force by virtue of international law, which he used then. Therefore, these cases do not stick with him. Next, please. And then, of course, उन्होंने बाकी NGOs को भी on take किया. Next. And then they concluded there are serious gross violations, including mass crimes, mass rapes, and other crimes against humanity. Next. But one must appreciate the role of our colleagues from Canada, and because they have nevertheless, kick-started an initiative which was lying dormant for a long time. So I think one must compliment them, notwithstanding the terms of reference and so on. So once this thing starts going, then we can move on. Now, just few minutes on what can we do from Pakistani side. Do we have a role from an NGO point of view to participate in the tribunal proceedings or to set up something else? Next, please. So for example, IPRI, I refer to my own organization, RSIL, can we do something? And there are multiple other organizations, that's why there's ... Anybody can take an initiative, step forward and say, well, I would be interested to participate. Next, please. For example, हमारी जो RSIL थी 1993 में, we had incorporated that. And we incorporated it based on, इसको आप एक नजर पढ़ लें, if you can पढ़ सकते हैं तो, the same international cooperation cannot be achieved unless the states and other international entities respect their obligation in international law. Acknowledging that the same cannot be done unless efforts are made for promoting the understanding of international law. Realizing that such measures have to be taken at national, regional, and international levels. Further mindful of the need to create a non-political and academic body dedicated to research-oriented activities at national, regional, and international level in the field of international law. It is hereby resolved to form Research Society of International Law having the following objects. Next, please. So ये उसके objects आगे जो 1993 में रखे हुए थे, और ये by and large वही हैं जो हम आज काम कर रहे हैं कि awareness, capacity building in international law, documentation, collecting. उस जमाने में Google नहीं था जब ये establish हुआ था, तो one was creating a library of international law texts available that can be looked at. तो इसी context में next please. We did publications, and most of these publications have been extremely useful in reverting very aggressive initiatives against Pakistan. Next please. अब हमने attempt किया, Jamal is the executive director who went to New York for ECOSOC की meeting के लिए जहाँ accreditation होती है, और फिर एक साल पहले मिनाहिल गई थी. Minahil जो थी, so she was recently married, she was mashallah pregnant at time, she traveled there, made a speech कि RSIL should be granted accreditation by ECOSOC. Next year Jamal went, RSIL should be granted accreditation by ECOSOC. India vetoed. And India continues to veto. So I think one request that we would make is if the Foreign Office could be facilitating us a little bit more on this. And if we have an accreditation, then we have a right of audience at any UN forum. Not only us, but I think there should be other organizations जिनकी accreditation की processes करने चाहिए, because then you have a right of audience. If you remember जो Info Lab में India ने क्या किया था? इंडिया ने वो ऑर्गेनाइजेशंस जो एक्रेडिशन हासिल कर चुकी थी मगर डॉर्मेंट हो गई थी, 10-15 मुख्तलिफ, कोलंबिया से, पेरू से, कहीं से, अब उसके जो स्पॉन्सर्स थे उनका दमखम खत्म हो गया था, उनका सांस फूल गया था, दे हैड स्टॉप्ड बीइंग एक्टिव. उनके पास जाकर दे बॉट द शेयर्स और दे आस्क्ड देम टू ट्रांसफर द एडमिनिस्ट्रेशन टू देम. उन्होंने कहा ठीक है, हमने गिव देम एक्स मनी एंड यू ट्रांसफर, एंड दे सडनली बिकेम एक्टिव, दोज ऑर्गेनाइजेशंस. सो hearing of the voices at ECOSOC level is important. Next, please. Abdul Hafiz Pirzada Saab came to RSIL in 2006, and he said that I'm simply overwhelmed by the dedication, commitment, and extraordinary legal acumen and expertise which is going into the development of this institution. I have no doubt it will serve the future generation of Pakistan, humanity as a whole. My profound appreciation, good wishes. Hafiz Saab ko isliye maine lagaya ki he's one of the most respected names in our profession in terms of his clarity of thought. Ab wo nahi hai is duniya mein, but when he came, he was very impressed. Even Ambassador Inam Saab, when he came to RSIL, he was very encouraging the work that we were doing. Next, please. Moving forward, next, हम क्या कर सकते हैं? कुछ तो मैंने बताया, RSIL चलिए आगे. फेडरल गवर्नमेंट बैक इनिशिएटिव कोई हो सकते हैं? नेक्स्ट, क्या मिनिस्ट्री ऑफ ह्यूमन राइट्स इस तरह का ट्रिब्यूनल एस्टैब्लिश कर सकती है? अफर्मेटिव कर सकती है. इट कैन इशू अ नोटिफिकेशन. It can say we will examine, we set up a group of 3 young international lawyers or old international lawyers, foreign experts. Sri Lanka ने ये किया था. श्रीलंका ने मुझे co-opt किया था. They requested the federal government that give us a name of international lawyer. And then they had me in one of their tribunals. So the Ministry of Human Rights के पास administrative flexibility है. ये Ministry of Kashmir Affairs के बाद भी है कि it can set up some sort of a, not exactly Russell, but something to that effect where you are able to document, because authenticity of the federal government की अपनी value है. Next. Statue backed initiative, यानी कि next जिस तरह next PIPS है. PIPS is a creation of a federal statue. So statue backed initiative अगर होगा उसकी legal sanctity globally accepted होगी. So it could be even आप कायदे-आज़म यूनिवर्सिटी से, तो मैंने इसलिए कायदे-आज़म यूनिवर्सिटी लिखा है, कायदे-आज़म यूनिवर्सिटी एक्ट कि as in capacity of registrar you could set up a tribunal, notify a tribunal for your international relations department or defense department जो भी आप पढ़ा रहे हैं, as an academic work. But since you are based, your creation, a creature of a statue, therefore you will have much greater authenticity. इसी तरह Pakistan Institute of Developmental Economics कि वहाँ economic exploitation कैसे हो रही है Kashmiris की, how are they being sidelined and so on. So the various aspects. Next, please. Karakoram University है. और जितनी universities are creation of statues, वो सारी universities are empowered to set up subsets of any nature. And therefore, registrars of any university, वो UMT है, वो लाहौर की कोई और है, they can set up these entities. Next, please. Civil society organizations तो खैर हैं ही. Next, please. IPRI है. Next. Pakistan Institute of International Affairs है कराची में, one of the oldest organizations. Hassan साहब ने set up किया था. मासूमा हसन को run कर रही हैं. And one of their big contributions is this Pakistan Horizon, a journal which is globally recognized. Next, please. So this would be my conclusion, ladies and gentlemen, that Russell is a great initiative. We should support that initiative. We should find ways, and probably our colleague from Canada will guide us better on that. But in addition to that, we should also do home searching in terms of what we can do. Thank you very much.
Thank you, sir. Now I'd invite Dr. Farhan Mujahid Shak, the Secretary General for Kashmir Civitas, for his presentation. Dr. Farhan, I hope you can hear us.
Yes, I can. Assalamu alaikum. Thank you very much for having me. Am I clear?
You're loud and clear, sir. Please proceed.
Thank you very much. First of all, I'd like to thank the Islamabad Policy and Research Institute for organizing such a timely and important event to talk about not just what's happening in Indian-occupied Kashmir, but also our successful tribunal that we just completed in Sarajevo, Bosnia-Herzegovina. And so I'd like to thank Brigadier Janjua, and I was thrilled listening to Amr Bilal Sufi Saab, who I've had the good fortune of meeting quite some time ago. I'm not sure if he would remember, but I remembered that vividly. So thank you very much, everybody, for inviting me. Just to kind of begin, you know, when anyone looks at, and I think Sufi Saab mentioned this very eloquently, that when we talk about a goal or a vision, then we can approach that either two ways. We can approach it in a series of instances, or we can approach it as developing a process. So when a group of us got together to establish Kashmir Civitas, we decided that we needed to lay the groundwork and create that ecosystem of resistance in several facets, and most of all the narrative, cultural, academic, international organizations approach. So we wanted to kind of start a process. And to do that, you may not have those huge bang events, but you will take those steps that hopefully will kind of create that snowball effect that eventually, with the passage of time and with more and more initiatives that are ongoing, it kind of just, it grows into something of its own. So that's kind of the attitude we had when we first began laying the groundwork towards eventually just, and this also is not the culmination of anything. I believe this is just the beginning. The Russell Tribunal is really 2 years of work that went into coordinating with Bertrand Russell Peace Foundation, which is based out of Nottingham in the UK. So I've been having discussions with them since 2019. And as was mentioned, the foundation itself just provides, if it agrees with the cause and it agrees with the direction of the tribunal, it will allow that organization or that institute to use its name, and it will provide other kind of expertise. But at the end of the day, the model and the way that it goes forward is completely up to the organizing body. And that was basically us. But we believed it was so essential to kind of revive this ad hoc tribunal, this citizens initiative against what crimes are being done in Indian occupied Kashmir. We believe that since 2019, especially August 5th, 2019, the narrative has completely swung in a direction away from India. India is going to have a very difficult time now walking back from the claims of its fascism. Just recently, it was all over the news when they were attacking the Christian organizations within India and froze their funds. So that's also something that I recommend, that we need to incorporate more and develop solidarities with those communities globally that are aware and actually extremely concerned about the treatment of the Catholic community, whether they're in Goa or in South India. And so building those solidarities, what kind of led to the whole idea of approaching the Bertrand Russell Peace Foundation. But we didn't stop there. I even spoke to Gianni Tugnani, who is the Secretary General of the Permanent People's Tribunal, that was also mentioned in the slide. So approaching both of them, getting them both on board, sharing with them the information that is available, the documentation, the credible reports, all of that was crucial in winning them over. And this began the process of how we wanted to start. And I agree with you that this is just the beginning, and there's many lessons to be learned and many improvements to be made. And we are committed to holding a series of these in the next 7 to 10 years. And we actually want to do them yearly. But once we had established a team and a network, location is very fundamentally important. And one of the things that I felt Kashmir has suffered by, it's been trapped in a false binary between Pakistan and India. And this has served nobody's interests other than India. And so India utilizes this sometimes intentionally to say that it's a bilateral issue, and then internally it says it's a non-issue, and it repeats the same internationally. But this has really done a great harm in moving the Kashmir cause forward. So we felt that, look, we are independent, but we believe in reaching out to all stakeholders. So we need to create a platform and a momentum that showcases what the people of the disputed territory actually feel, without anyone being able to falsely misconstrue us and our intentions or our work as somehow being the product of a particular state or a particular organization other than who we are. And that's fundamental. In my discussions with Richard Falk, who was supposed to come, by the way, and who had committed to coming, but unfortunately last minute things had arisen. But nonetheless, we said this is a Kashmiri-run, Kashmiri-owned initiative, and nobody can discount that. Nobody could rubbish that away, because there is this type of assumption in the international arena that this is a matter between India and Pakistan alone, and they almost want to wash their hands of it. So those are some of the things that we thought we had to kind of challenge. And, Professor Sufi mentioned the 5 questions, that we had our own 5 questions that we had given the judges. Based on that, the judges released these facts that we felt are critical towards, reinterpreting and kind of putting forward the Kashmir narrative in a new way. First and foremost, we need to be able to recognize that, as was mentioned, that this is disputed territory. That's fundamental to how you you develop your logical stance in speaking to someone, that these are a people, they have their own language, their culture, their traditions. They are being denied their right to express freely. There is heavy militarization, upwards of 900,000, some even say more. Just on the line of control of the ceasefire line, in the last 4 or 5 years, almost 10,000 violations. Like, imagine the amount of atrocities that have happened and that are ongoing. We could go on, and I'm sure all the esteemed panel is well aware of the attempts at demographic flooding, the changing of the streets and the names, the culture, the false history that they're perpetuating, everything. As a matter of fact, I detail all of this in my forthcoming book, because I believe it's so important. Many of us have been a victim of that too. Those false histories that have created a false social imaginary that then kind of inhibits resistance. So we needed to do that. And our questions, actually, just to kind of go over them quickly, was the first question that we told the judges to consider is this a separatist or a decolonial movement? We wanted our esteemed judges to consider the ways that since 1846, when the British militarily supported a non-Kashmiri family to take over a territory, that began a process of creating fake history, changing the culture, the region of and presenting a false narrative. We also wanted them to consider, is India operating a settler colonial apartheid state in the disputed territory? And that's how we also want to frame it. India is operating an apartheid state inside as its occupation in Indian occupied Kashmir. Of course, do the enforced disappearances, the mass graves, snatching of the bodies of deceased, not allowing the last rites, do all of these amount to crimes against humanity? And then the final two, and I believe were very critical, important points that also were motives for why we chose Sarajevo. The genocide. The Jammu genocide, of which my family is a product, is one of the least studied genocides, where upwards of 500,000 people, and the official statistic is 237,000 people were massacred, completely changing the demography of the Jammu region. We don't have a memorial for that. We don't have proper academic work, not enough. And so we felt that going to Bosnia would facilitate and would teach me as well, and which is now like another positive news I'd like to share with everybody is we've now partnered with the Srebrenica Genocide Memorial Center. The head that is Dr. Ahmed, and the tragedy and the pain, it's horrifying. And we want, interestingly enough, how they created an entire research industry around what happened. And we actually traveled to Srebrenica. The team of us and a group of us went there the following day, which is such a painful and transformative experience. But I would also like to say that he specifically thanked Pakistan. He said Pakistan and Turkey were two countries that really had supported Bosnia during its difficult time. So nonetheless, that was another question on, can the Jammu genocide be classified as a genocide? And what could we do in that regard? And that became the focus then. The tribunal is preparing currently, and of course, is underway of making genocide one of the key accusations against the Indian state. And as of course, the esteemed panel know that the including of the Patiala Brigade at that time with the Indian government clearly makes the Indian state complicit in the massacres that happened. So we need to do more on that. And that was one of the driving forces as well of why we chose Sarajevo. And lastly, look at the neighborhood that we're in. Just the other day, there was the UN Security Council issued a statement cautioning against the spread of nuclear weapons. I think it is so interesting and indicative because the area of the world most likely to endure this kind of a catastrophe is the area that involves Kashmir, Pakistan, China, and India. So that was the final, and our final session was on that nuclear flashpoint. And we had brought in Professor Brian Toon, who is a specialist on this matter, to share his thoughts on how real this threat is. So nonetheless, that kind of gives you an overview of we tried to achieve. You know, alhamdulillah, Rabbil Alameen made it very successful beyond our expectations, considering the Omicron scare and we had more than 70 people fly in to Sarajevo, of all places. And we had a packed hall, and we had kept the proper social distancing practices, and even though the entire hall was packed. And so we're very happy that so many people that came to us afterwards were just thrilled that they had no idea what was happening in Kashmir. So that in itself is a major victory, that we are educating people on what exactly this fascist Hindutva government is doing in the disputed territory, how it's been bullying, and how it's been creating chaos along the ceasefire line or line of control. Every single person we spoke to there was, and as you know, that many of the evidence did so extremely carefully. We had a special room set up in which the judges were there, in which privately these Kashmiris directly from Indian occupied Kashmir came and gave testimony. Under anonymity to everybody else, except for the judges directly from there. So we're already in the workings of how to pursue it. Thank you everyone for patiently listening, and I'll be free to take any questions later on if necessary.
Thank you, Dr. Farhan. Next up, we have Dr. Raja Kasir Ahmed for his presentation.
Bismillah ar-Rahman ar-Rahim. Assalamu alaikum, ladies and gentlemen. Good day, Ed. So the topic is very important and significant, and much has already been said. Most of the aspects which covers legal underpinnings have been covered by our very esteemed panelist, Mr. Ahmed Bilal Sufi. And much of the insight over the Russell Tribunal has been highlighted and underscored by Dr. Farhan Mujahid Chak. I would not be trying to be repetitive in my talk, which would be definitely brief because much has already been said and stated. So what I'll be trying to look into this talk or presentation, which is not a formal presentation, PowerPoint though. So is about how this contemporary landscape, it has been transcended at the international system level and at the level of international society. Because if we tend to look at the international system level, so we come across an unpopular opinion that India has largely been able to get away with this diplomatic fallout of the revocation of Article 370. With a very few countries who have outrightly condemned this act of the illegal scrapping of the Article 370, and a few international organizations taking notice of this thing. Otherwise, India managed to get away with the diplomatic fallout. And there are various reasons for that. One is the active diplomacy. Second is the economic success of India at the international level. And there had not been much internal resentment. One, due to the repression and the lockdown which Indians, they have put into place. And secondly, it's very unfortunate, but when it comes to Kashmir, so Indian civil society, Indian center, Indian right, Indian left, they are of the same opinion. So Kashmir is something, I mean, which does not generate much of the active dissent in India even. So that's why we see that despite 2 consultative meetings of UNSC, we did not come up with any substantive outcome, let alone a non-binding resolution. So despite this, at the level of international society, we see certain organizations like Kashmir Civitas, Kashmir Scholars Consultative Action Network Group, War Crimes Against Kashmir. So these are some of the notable organizations which are working in this very ambient domain and are highlighting and doing their work in this capacity. Kashmiris right now are living with a very agonizing reality where a series of draconian laws, initially they were FSPA, then TADA, then POTA, and now UAPA, Unlawful Activities Prevention Act, where people are being put into incarceration over their intentions, over their suspected intentions, that Indians, they believe that the Kashmiris are a youth or a juvenile. I mean, they just suspect him to be involved into some kind of terrorism, or maybe perhaps, someone who can be a potential recruit. So that's why they are picking them up. They are putting them into incarcerations, and thousands of young juvenile Kashmiris are into far-flung jails, which are not even into the notice of their own families. So Kashmiris, after having one entire generation of half widows, is now living with half a new generation, which is nowhere, which stands nowhere, which can't be even located. Then Kashmiris, they have been scourged with the first massive mass blinding of the human history. This is such a tormenting reality, and the most egregious war crime which has been committed, at least in the recorded human history. But Kashmiris, they have been victim to that. Then, as you know, the 4 themes which have been highlighted under this Russell Tribunal, and Russell, while setting up this tribunal, he is found to set it on record that may this tribunal end the crime of silence. So let's hope that, this Russell Tribunal, which has been instituted on Kashmir, it also ends silence on Kashmir. The reality is so egregious that, because we have been taught and we have been enlightened by Amr Bilal Sufi on certain aspects of international law. But let me bring in something which is again very horrendous, that Kashmiris who have had pledged their lands against the bank loans in J&K when this Article 370 was in place, and now when it has been scrapped, so by then their lands could not have been transferred to non-Kashmiris, but now these Indian banking laws, they are being used as tools, and their lands are transferred to non-Kashmiris. Hence, a very subtle and a very nuanced internal change in demography is underway. And this is not something which is only being done implicitly in a subtle or a nuanced manner. As of today, approximately 5 million non-Kashmiris have been issued domiciles for their settlements in Kashmir. So at the same time, people, I mean, there is again a very dastardly gender dimension to this conflict, that men are getting killed and women are getting raped. This is such a tormenting binary, and this is such a egregious thing that that certain degree of different gender treatment is being put into place. Kashmiris have been stripped off from their right to live with dignity. And Genocide Alert has cautioned an impending genocide in Jammu and Kashmir. There is likelihood of a Gaza-like situation in Kashmir. And it has been substantiated in the Russell Tribunal as well, that Kashmiris, they are to be made minority in their own lands. So the apparent reality and the contemporary landscape is much more serious than it's projected. And Indians, the way they are, I mean, the proto-fascist rule in New Delhi and this Hindutva juggernaut, it is said to engulf Kashmiris, and they are doing it under two mantras. One of counter-terrorism, and secondly, they label everyone who highlights these human rights violations as pro-Pakistan. So these two binaries of being pro-Pakistani and anti-state, and what they famously call as Tukde Tukde gang. So this is what media rhetoric which they are following for the people who are against the human rights violations. A very, very rare of the voices there, as I said, that over Kashmir, they have almost a kind of a consensus. So, and second is counter-terrorism. And Kashmir, since it has been reoccupied on August 5th, 2019, so technically killing of one Kashmiri is also a genocide. Indian position over Kashmir after August 5th, Ahmed Bilal Sufi Sahab can bear me out, is very similar to as Russia's position on Crimea after August 5th, 2019. And the way Indians, they have unleashed an uncharacteristic and appalling war which is multifaceted against Kashmiris. It is not just a military war. It's a political war. It's an economic war. It's a cultural war. It's a war against identity as well. As my esteemed colleague Farhan Mujahid Chak said, that they are even fabricating the history. And very recently, the way Khurram Parvez has been picked up and is being put into incarceration, it in itself bespeaks how affairs are underway and how things they are progressing in Jammu and Kashmir. So what needs to be done? That's the most important thing. And much of the lawfare options, they have been highlighted by Ahmed Bilal Sufi Sahab. We'll again have to think for some out-of-the-box solutions as well. The happy lucky go trilogy is, likely to be counterproductive against the mammoth challenge and the kind of, the impending threat which Kashmiris are facing, a threat of ethnic cleansing and a threat of genocide. To add to the options which Ahmed Bilal Sufi Sahab has pointed out, a bureau on Kashmir affairs can also be set up. If not at home, somewhere at abroad. Secondly, engaging international audience is very important. I mean, I do appreciate initiatives like this. IPRI has taken up a very significant and a very timely initiative. But engaging domestic audience would be following the approach of convincing the convinced. We all are almost convinced with this, that Indians, they have unleashed terror against Kashmiris. Kashmiris are suffering, and wars and the atrocities are being perpetrated against them. We need to take it to the international audience as well. We have to engage more and more international audience. If international system, which is dichotomous, which is paradoxical, and which is driven by the economic underpinnings, and Indians are managing to get away with their economic clout and active diplomacy, why not we engage international community? We can take it to the international community if international system is non-responsive. We can engage more and more international audience. Now, this pandemic has made virtual a new real. So, we can have more and more initiatives which involves foreign speakers, foreign audience, and, the people are the human rights activists across the world. So that would, though have slow trickle-down impact, but would at least have more noticeable and substantive dividends. So again, opening up a government in exile can be one of the options which should be reflected upon and pondered upon. If we come up with the option of government in exile, so, and then that would be representative government for Kashmiris, because eventually what Pakistan can offer to Kashmiris is diplomatic and political support. So the battle is to be fought by the Kashmiris themselves. So when the indigenous voices, they would be speaking for themselves, or when they would be getting representation at the forums, so that would again increase, and that would make the response more robust and more substantial. So this Russell Tribunal, it is indeed an ice-breaking, because for the past, at least, during this COVID, this Kashmir issue has been slightly subsided. I extend my deepest encomium to all the organizers who have, worked tirelessly, as our fellow colleague was telling, that they have been into this for past 2 years at least. And it will definitely start, or it will commence more discussions, more avenues, more prospects. So all those aspects, and I definitely concur to one argument of, though I agree to all of them, but one argument which Amir Bilal Sufi Sahab has presented, that we will have to take a specific issue to a specific tribunal, to a specific body. If we believe that, we can take this issue into collectivity and can present it into some kind of court, so I don't think so that is likely to work. So we have to engage a very competent and a very effervescent team of international lawyers. Kashmir is a legal dispute. So, and it has to be fought by the international lawyers, because all are outstanding issues, not just Kashmir, whether it is Siachen, whether it is water, whether it is terrorism. So all of these, they have the legal connotation. So we'll have to initiate a lawfare against India. Indians, they have persistently invested into a narrative post-Kargil that Pakistan is a rogue state. Amir Bilal Sufi Sahab would bear me out, but Indians, they want to create an image at international level or at international system that Pakistan, since it is a rogue state, so the applicability of international law, it should not be, presciently applicable to Pakistan. So India should be allowed to deal with Pakistan unilaterally. And that's what they tried to do after Pulwama as well. Their initial justification to this cause was that what is wrong if India has done so? America has also done it in the case of Abbottabad. So they try to act unilaterally. And I remember once this Brijesh Mishra, who was advisor to BJP, when I was conducting my PhD research, and I'll take a little moment to add to publicity, because you have introduced me yesterday. My third book has been published by Palgrave Macmillan, and it is Pakistan Factor and the Competing Perspectives in India. So it is just yesterday published. So I haven't received my author copy as of yet. So when I was conducting this research, so during an interview, he said something which was very revealing. And he said that Kashmir to India is the litmus test for its great power status. We, through Kashmir, want to demonstrate that international law is for the lesser nations. India is a great power. And we can go with our impunity, we can do anything. And international law cannot come and it cannot debar us, like the major powers they do. And he said one thing, when he said very informally, उसने कहा बंटवारा एक हुआ था, दूसरा नहीं होगा. So this is the mindset Indians are living with. With this, kind of you are, I mean, I very, I'm just concluding. So I believe that this issue is still alive due to Pakistan's active diplomatic and political support. And we cannot lose this war unless we give it up. In Chinese proverbial thinking, there are three forms of disputes. वो कहते हैं एक वो disputes होते हैं जिनको आप those who emerge in the form of crisis और आप उनको overnight आपने resolve करना होता है. दूसरे वो होते हैं जो time taking होते हैं, उसके अंदर legalities, intricacies होती हैं, you have to bring in them and you resolve them. And third are the disputes for which you have to raise the generations, and you have to cultivate a narrative, and you have to be adamant that you will never back out on them, and you will have to contest them. Or in public policy, even there is a 3P model which says that whenever there is 3Ps, politics, policy, and problem, there opens or pops up a window of opportunity. We right now have a window of opportunity. There are all 3Ps available. We'll have to work on it, and we'll have to move towards some substantive outcomes. With this, I seek your permission. Thank you very much for being out. Thank you.
Thank you, Dr. Raja Kasir. Now we'll hear from Mr. Hassan Aslam Shah, who's joining us virtually.
Ahmaduhu salli ala al-Kareem. Bismillahir Rahmanir Rahim. Just confirm, please, if you are able to hear me clearly.
We can hear you.
Thank you very much. Thank you. Firstly, it is an absolute honor and privilege for me to be invited to this very important seminar, which is on the Russell Tribunal, that highlights the atrocities committed by the settler colonial project of Hindutva in Indian illegally occupied Jammu and Kashmir. Now, the reason why we have convened today on the 5th of January, which is Kashmiri's Self-Determination Day, is a very important milestone. I thank the IPRI for this initiative, and I'm sure that this initiative will lead to further momentum to the Kashmiris' right of self-determination, which has been denied to them for the last 70 plus years. So firstly, I will just give a brief overview of the objective of my talk. What is it that I want to talk about, and why is it that we have gathered here today? So the Russell Tribunal is, in my view, a resetting of the narrative on Kashmir. We know that the international community has not been active in highlighting the atrocities that are being committed in Kashmir. And there has been a lethargy that has seeped and permeated into the fabric of the international system. And that has tied the hands of Pakistan, which is ideologically tied to Kashmir, as well as the right of self-determination of Kashmiris. But through the Russell Tribunal, we are recasting the importance of Kashmir at the international level. And this, I believe, is a very, very important aspect that the Russell Tribunal has managed to accomplish. I will now touch upon what is it that I will be talking about. My focus will be on lawfare. Lawfare, as we know, is the use of law as a weapon of war. And it is a very important and essential component of statecraft in the 21st century. So allow me just briefly to touch upon two overarching themes that I see in international law and international relations. The first is the law of power. As I mentioned, there is a lethargy in the international community. International law has the tag fixed on it that it lacks teeth. It is hostage to geopolitics, as a result of which we do not see the enforcement of international law as much as we would like to see. This has left many self-determination movements, specifically the Palestinians and the Kashmiris, in a lurch. And this is something that works against them. Now, having talked about the law of power, there is also another very important vertical that we must never forget, which is the power of the law. And that is known as lawfare. Lawfare, as I mentioned earlier, is the use of law as a weapon of war. It is an essential and vital tool of statecraft. It is the means for bringing to bear the entire force of the international system on an oppressor like the BJP government in India that has been oppressing the Kashmiris. Now, why is the Russell Tribunal a lawfare on Kashmir, or how does it help Pakistan's lawfare on Kashmir? Number one, it speaks law to power. It resets the narrative on Kashmir. It leads to a catharsis of the global conscience. You see, stories are all predetermined. They have all seeped into the global conscience, and the Russell Tribunal is resetting the narrative. It is basically changing the lens through which Kashmir has been viewed. And it is now time that we use the Russell Tribunal's momentum to take the Kashmir struggle forward. Now, I will just quickly touch upon the details of how the Russell Tribunal has refreshed the Kashmir struggle in the international arena. The most important thing that the Russell Tribunal has done is that instead of getting bogged down by intent under international criminal law, which is the requirement for prosecution for crimes such as war crimes, crimes against humanity, and genocide, the Russell Tribunal is historicizing intent itself. Instead of looking at the struggles that, instead of looking at the prosecution of perpetrators of crimes, which has not happened so far, the Russell Tribunal is asking us to look at the entire social, political, economic, and cultural subjugation of the Kashmiris that has happened over the years. Now, this changes the narrative very importantly, because as a result of this, the world will not view Kashmiris as only a people who are being violated through international law, but rather as people who are being subjugated and who have been oppressed. Now, Pakistan's case on Kashmir and Kashmiris' right of self-determination is very clear. The fallback for Pakistan is the United Nations Security Council resolutions, in particular UNSC Resolution 47, 91, and 122. These resolutions very clearly state that the expression of will shall be expressed in the manner of a free and impartial plebiscite. This is very clear. It makes Kashmir an international dispute. There are no two ways around it. The international legal system, which is the various international treaties, international instruments, also clearly lay down that right of self-determination is a non-negotiable. We have two principles. One is the principle of jus cogens in international law, which is a peremptory norm of international law from which no derogation is possible. The meaning of this is that this is a non-negotiable principle of international law. There is absolutely no way that the international community will condone a violation of this principle. The second important principle is known as erga omnes. Erga omnes means that the obligation is owed by the entire international community to all other members of the international community. Over the years, the International Court of Justice has laid down case law, which has elaborated upon the right of self-determination. Two very important cases that are directly relevant to the Kashmir question, in my view, and the Kashmiris' right of self-determination are the Chagos case and the East Timor case. And I suggest, after having studied international law over the years, that Pakistan's lawfare should against India in relation to Kashmir and in relation to the right of self-determination of the Kashmiris should consider and seeking an advisory opinion of the International Court of Justice. Now, the advisory opinion of the International Court of Justice is not legally binding, but that is not the entire story. It carries a lot of legal weight. The International Court of Justice has held in the past that as long as a question has been categorized as a legal question, even though it may contain political and historical questions, which are part of the legal question, it does not prevent the ICJ from adjudicating over that dispute. So far, 24 advisory opinions have been sought from the International Court of Justice. As long as the agency of the UN that has sought the advisory opinion of the ICJ is doing so in light of its own activities that it's authorized to undertake, the ICJ will render an advisory opinion. The advisory opinion is very important because it resets the narrative. In relation to the Chagos Island case, after the ICJ's advisory opinion was sought by the United Nations General Assembly, there was a resolution that was passed by the United Nations General Assembly by a vote of 116. And interestingly, India was also in favor of that resolution, whereby the International Court of Justice required the Britain to return the control of the islands to Mauritius. One of them was the Chagos Island. Now, there are very clear parallels that I see between Chagos Island and the Kashmir question, and allow me to very briefly elaborate on this because I don't have the luxury of time. In the Chagos Island case, Kashmir, like the Chagos Island case, is an incomplete agenda of partition. There are many questions that abound to this day about the status of Kashmir. The second is the right of the people has been denied. Now, this again is a parallel between Kashmir and the Chagos Island case. In relation to the East Timor case, again, briefly, I'll touch upon this. Like East Timor, Kashmir has an uncertain status. Let's remember something, that the original United Nations General Assembly Security Council resolutions, in fact, the only Security Council resolutions on Kashmir do not talk about the right of self-determination of Kashmiris per se. They only talk about the right of the Kashmiris to join either the dominion of India or Pakistan. So this means that Kashmir, like the East Timor, has an uncertain status. And second similarity is that like Kashmir, like East Timor case, the Kashmiris are having the right to determine their status through the method of a free and impartial plebiscite. The only thing lacking in the case of Kashmir, which we can attribute to geopolitics and to the theme, the law of power, which I mentioned earlier, is that the international community is in a slumber. It is not willing to intervene and to prevent the atrocities that are happening on a daily basis in Kashmir. But we can change that. What is very important is that when Pakistan, and if Pakistan decides to seek an advisory opinion of the International Court of Justice on the Kashmir question, it all will depend on how we frame this question. It is very important that we focus on the right of self-determination of the Kashmiris and do not frame the question as a territorial dispute between India and Pakistan. Although, even if India objects that this is essentially a dispute between India and Pakistan, the ICJ's previous cases have laid down that even if the main question relates to territorial disputes, that does not prevent the ICJ from assuming jurisdiction and giving a judgment on a particular case. Second, and most importantly, in my view, Pakistan should also challenge the very instrument of accession that has formed the basis for India's claim over Kashmir. I believe that the instrument of accession was the result of either coercion or duress, or it implies that the Maharaja Hari Singh was not in control over the territory of Kashmir. If he was in control, then he would not have asked for India's military intervention, as has been alleged. So this is very, very important. We should keep this in mind. And whatever our ultimate question is before the International Court of Justice, if we decide to pursue this option, then we must frame our question in the proper way so that it leads to a favorable decision for us. Now, the most important question that in relation to this lawfare would obviously be, how does Pakistan get that international clout, which is required by it, to get a resolution passed by the United Nations General Assembly to refer the matter to the International Court of Justice for an advisory opinion? Now, let's understand that this will require our Foreign Office to do a lot of heavy lifting. We do have an example in the form of the recently concluded OIC summit on Afghanistan, whereby the Foreign Office flexed its diplomatic muscle, and it did the unthinkable by getting the entire world to sit under one umbrella and to discuss the issue of humanitarian assistance to Afghanistan. So if we have done that, then we can also flex our diplomatic muscle on Kashmir, and we can try to convene a global conference on Kashmir in which we highlight the importance of drawing the world's attention to Kashmir. And alongside this, automatically what we will achieve is that we will be able to get support of the international community from individual countries who can then help us in framing the legal question that we can send to the International Court of Justice for an advisory opinion. This question, as I have mentioned earlier, has to be characterized and framed in the right manner. And we need to make sure that this question is covering all the legal issues that we feel are relevant to the right of self-determination of Kashmiris to be realized. Now, this is one lawfare that we need to consider. There are some other lawfares also, which I believe are very important, which we should be building upon in light of the Russell Tribunal. One of them is media lawfare. We live in the age of social media, in which a tweet or a news clipping or a news item on an issue can thrust that issue in the global limelight. Leading from the Russell Tribunal, we should be getting space in international media. We should be convening sessions and talk shows on the Russell Tribunal, whereby we should be highlighting the work that has been done by the Russell Tribunal, how the Russell Tribunal is leading to the progressive development of international law, how it is bringing together a diverse set of people from different corners of the world to discuss and debate the atrocities that have been committed against the Kashmiris. Together with this, we should also, as a matter of state policy, contribute to international journals of repute. We should get our voices, our views on Kashmir to appear in those journals, because this will lead to a further voice for the Kashmiris, as well as enable the world to see how the Hindutva regime in India is violating the laws and how it is destroying the fabric of the Kashmiris. Another very important thing that we must look at is not letting the line go slack. And by that, what I mean is that we should make sure that we do not fall victim to the short-lived public memory. The Russell Tribunal has done it has achieved something that was unthinkable on Kashmir by convening the session last month in its inaugural session. We should convene further global conferences, which should be attended. We should send invitations to international jurists. We should engage international influencers, media persons, academics, lawyers, and we should debate the Kashmir question in light of the findings of the Russell Tribunal. Because the Russell Tribunal has also sent its report to the United Nations agencies, to the EU Parliament, and to the different governments around the world, or it will send the details of the inaugural session. We should follow up on that. We should make sure that the voice and the reasoning and the verdict of the Russell Tribunal reaches the four corners of the world. We should take this as an opportunity to wage an aggressive lawfare against India. We should not let them change the narrative and to take the narrative hostage, which they have successfully done over the years. Now, allow me to also touch upon the, in light of what I mentioned about the importance of reaching out to countries on a one-to-one basis, the state should also consider setting up a think tank on international Pakistanis. And the purpose of this think tank should be to bring together different voices on Kashmir. Because as one of the speakers in this session mentioned, we don't want a confirmation bias. We don't want to get a confirmation from our domestic audience. We all agree that Kashmiris deserve the right of self-determination. What we need is the consensus of the international community. And for that, we need to cast a wide net. Today, we live in a world in which a plethora of international laws, treaties, customary norms are applicable in different dimensions. We should tap into those resources, and we should make sure that we benefit from those international conventions, international rules, international treaties, and international norms. Now, this is our moment to do so. Lastly, I will conclude, because I'm short of time, I will conclude by saying that India has sabotaged or is trying to evade international criminal responsibility for what it is doing in Kashmir by virtue of its declarations that it has filed at the International Court of Justice. Every country in the world has the right to file unilateral declarations, and India is evading responsibility. But Pakistan should not let India get away with murder. The Russell Tribunal has convened a seminar and a session in the court of public opinion. If we can change the hearts and minds globally on the right of self-determination of Kashmiris and make the world see the real face of secular India and what it has done and is doing to the Kashmiris, then I believe our lawfare stands a great chance of success. What we need is momentum. What we need is clarity of thought. And what we need is that resolve that nothing in the world can stop the Kashmiris from achieving the right of self-determination one day. With this, I come to the end of my talk. Thank you very much. And once again, I'm honored to be here.
Thank you, Mr. Hassan Aslam Shah. Ladies and gentlemen, we'll now commence with the question and answer session. For convenience, we can have 2 or more questions, which will then be put forth to our panelists. If you do have a question, please raise your hand, and upon acknowledgement, state your name, affiliation, and the panelist you wish to address your question to. Can we have a show of hands, please? Ambassador.
Yeah, thank you very much. My question is to Mr. Ahmed Bilasuf. Forum that would take up those issues, would ask India to stop those violations in principle. Does it also mean that it would also force India to go for the plebiscite or grant right to self-determination? Because what we have been seeing over the years, because for India there are many according to their own reckoning, they have their own arguments to support their occupation of the Kashmir. Your take.
Yes.
Thank you very much, Ambassador Sab. There is, as I said earlier, there is no comprehensive forum per se that can direct or give a complete declaration about Pakistan's favorable stance on the case. And also, it will be difficult to find a forum which can direct India to conduct a plebiscite because of the nature of jurisdiction that the global forums have. They have limited jurisdiction. So we have to tailor our relief based on what is the mandate of various forums and can we get a door opening for that. One option in this respect could be the courts in India. We don't know if they will be favorable. A little while ago, the judges of Supreme Court of India were actually quite hostile to the executive branch of the government of India. And again, if you may recall, the Jammu and Kashmir High Court came out with two very distinct judgments, which were also supporting the view of the Supreme Court of India. So that could be a very interesting venue to explore. Probably now it may not be as effective given the way the Supreme Court of India is going along with the executive branch of the Union of India. But one can explore other forums. You can possibly make an effort for a declaration. There is nothing, no one stops you from creating an enactment which gives Pakistan transnational jurisdiction of declaring certain things. So there are various options and one can sit and explore on them more meaningfully. Thank you.
Bye.
Thank you so much. Thank you so much. My name is Jafari Maitri. I belong to UP. I have a brief comment. Recently, probably last month, the United Nations General Assembly unanimously adopted a resolution which was sponsored by Pakistan as well as supported more than 71 nations. It endorsed the right to self-determination, universal right to self-determination. But having agreed with that that resolution lacked it didn't properly use the word of Jammu and Kashmir in that. It was a very vague sort of resolution. So I'd like to have a take on that from you. And from you, sir, you have raised a very pertinent point about government in exile, the Kashmir's government in exile. What parameters do you see for that? Because we have seen in recent history that there have been several Middle Eastern countries who have taken their governments in exile, like Iraq, Syria, and even after the Khomeini revolution, the opposition in Iran. So what parameters do you see for a government in exile? And do you think the Azad Kashmir structure that we have here can be a government in exile? And should the Pakistani political parties hobnobbing with the Kashmiris, should they distance from that infrastructure? And should the indigenous Kashmir be the sole representative of Azad Jammu and Kashmir? Can that act as a government in exile? Thank you.
Thank you very much. What was your question to me? I was listening. UN resolutions, yes. UN resolution on self-determination and by the Security Council is actually a very welcoming development given the circumstance. UN General Assembly kiya, security. Even if it's General Assembly, it's a larger consensus. You know, the number of people, number of states there are. Obviously, General Assembly में resolutions ज़्यादा आसानी से पास हो जाती हैं. लेकिन जब आप law point को reaffirm करने की बात करते हैं, तो General Assembly की large base का state practice पर बड़ा positive role आता है. तो इसलिए it's a good development. और Pakistan needs to be given credit for that and other states as well. ये चीज़ इस चीज़ को establish कर रही है कि जो basic concept है self-determination का वो अलाइव है, उससे रिलेटेड मामलात पर बातचीत आगे चल सकती है, उसको बिल्ड किया जा सकता है, तो वो बिल्ड हमें करना चाहिए. जो आप चाह रहे हैं कि उसके से टुथलेस रेजोल्यूशन, यस, पाकिस्तानी लोगों की एक्सपेक्टेशंस बहुत ज़्यादा बहुत जल्द रिजल्ट्स की होती हैं. इट टेक्स अ वाइल और इट टेक्स अ टाइम बिफोर यू इवेंचुअली यील्ड दोज रिजल्ट्स. कि जब आप एक थीम को लेके चलते हैं, फिर थीम से रिलेटेड केस स्टडीज की जब साल बाद कुछ महीने बाद कहीं गुफ्तगू होगी, उस रेजोल्यूशन स्पेसिफिक कुछ सेमिनार्स होंगे, उसमें सेल्फ डिटर्मिनेशन की, फलस्तीन की बात करेगा, कोई ये बात करेगा, एंड देन दैट आर्गुमेंट विल बी ट्रैश्ड फर्दर.
Yeah, my resolution, this resolution is adopted every year. It comes from the third committee to the UN General Assembly. In the third committee, there is an agenda item on self-determination. Every year, Pakistan sponsors this resolution with a number of other co-sponsors, but it is a general resolution for self-determination only. It does not specify any particular country or territory. So we have been sponsoring this for the last 20 years or so. This is not new. So do not expect any results or major results from this resolution. इसमें बहुत से Africans भी मिल जाते हैं, बहुत से Asians भी मिल जाते हैं. Even India joins in the consensus. But that does not mean that India will accept the Kashmiris' right to determine their future. तो इसलिए इसमें ज्यादा हमें expectations नहीं build करनी चाहिए इसके ऊपर. दूसरा सवाल उन्होंने पूछा था कि आजाद कश्मीर में गवर्नमेंट इन एग्जाइल हो सकती है या नहीं, उसका जवाब.
Well, coming to your question of government in exile, it can be one of the options. As you know, I didn't say that it should be the option. It can be our option. It has been tried in the past, though it was JKLF, Jammu Kashmir Liberation Front, which it tried in the early 1990. This option they tried to work upon, but it didn't work. My point, since we were running short of time, but my argument concerning that is that we have to have an indigenous inclusive narrative. So when we talk of inclusive narrative, it means that we have to involve people from all the conflicting geographies. So all those conflicting geographies which constitute this mosaic of Kashmir conflict, it should have people from Ladakh and Leh, it should have people from Jammu, it should have people from Valley, it should have people from Gilgit-Baltistan, it should have people from Azad Kashmir. So I think that is only achievable if it is to be executed somewhere outside rather than this Azad Kashmir. I mean, Azad Kashmir can be significantly empowered, but definitely there would always be, it will be always under an impression that it is under the control or administration of Pakistan. So that's my point, that we have to have indigenous and inclusive narrative over Kashmir.
Thank you, sir. We did have another question. Sorry.
When we talk of a government in exile, you have to be clear what it means. The UN Security Council resolutions talk of a plebiscite, giving the Kashmiris the option to join India or Pakistan. They do not give them the option to set up an independent state. If you help in setting up a government in exile, you're opening up the third option, which is independence of Jammu and Kashmir, which is not included in the UN Security Council resolutions. Therefore, a conscious decision has to be taken by Pakistan that it is prepared to give independence to Jammu and Kashmir whenever such a time comes, before you can work for the establishment of a government in exile, either in Azad Kashmir or anywhere else. And this is a political question, and I suspect that no government in Pakistan would like to deviate from the UN Security Council resolutions at this stage.
You had a question?
I have a question from Hassan, Shah, and then Mr. Ahmed. From Hassan, the question is, you mentioned IIOJK and its advisory jurisdiction, that Pakistan should take up the case. But would it not be, dependent upon India's acceptance of IIOJK's jurisdiction? And Ahmed Sufi, we spoke about war crimes, and we know that war crime is conducted by an occupation army, and after those UN resolutions which allowed India to keep a certain number of troops there, do you think we can connect the Indian presence with the occupation or treating Indian army as an occupation army, so that the war crimes could be attracted?
So I'll thank you very much, firstly, for this very, very important question. The purpose of the advisory jurisdiction is to avoid the feet dragging by India. So in the case of a contentious jurisdiction, you are bound by the declarations that the countries have made at the International Court of Justice. India has made very recently, it's made a declaration in September 2019, whereby it has given out the circumstances in which it will not accept the jurisdiction of the International Court of Justice. Now, when it comes to the advisory jurisdiction of the International Court of Justice, you're not bound by the declarations. So in other words, you don't have to go through the rigorous procedure of checking out and looking at whether a country accepts jurisdiction or not. Now, interestingly, I gave you the example of the Chagos Island case. The Chagos Island case, this question that arose in the Chagos Island case in relation to the decolonization of Mauritius, in this case also, the question, the ICJ did not look at what the objections of Mauritius and UK were to the jurisdiction of the ICJ. It became completely immaterial. So if Pakistan takes the route of the United Nations General Assembly, that United Nations General Assembly passes a resolution by simple majority, and this question then goes to the International Court of Justice, then there is no way that India can stop it from going. As long as we are able to do our work by building a consensus of the international community to take the Kashmir question very seriously. And as I mentioned earlier, we need to be very careful in how we frame the question, because in the case of Chagos Island, what was done very cleverly was that the question was framed in such a way that it did not refer to sovereignty, which, as we know, is one of the fundamental essential tenets of international law, but it referred to decolonization. Similarly, we should bring in other sub-questions or sub-issues like the right of the violations of international human rights law, the right of self-determination of the Kashmiri. So we need to be very careful in how we frame this question. So to summarize the answer to your question, no, India cannot stop us from going to the International Court of Justice if we take that route, because India cannot stop it from happening.
Thank you very much. If I can add to what Hassan just said, in addition to the care that needs to be exercised for the framing of the question, we also have to be mindful about the jurisdiction of the international organization which has the mandate to make a referral to the ICJ, because normally they want to be sure if the question that is being formed can be within the jurisdiction of the statute of that organization, whether it's WHO in case of 1996 legal opinion relating to nuclear issues and others. So if we are able to cross that hurdle and then the care in the execution of the question, then it can be examined whether we can go to ICJ and how, and what it's then thereafter what needs to be done. Coming to the specific question that you addressed me on, that we are presuming that Indian Army's positioning there is based on the UN mandate, which is partially true historically. But after Article 370 and their exercise of executive authority through 370 for good 40, 50 years plus, now the mandate is being drawn directly from the Union of India and from the Constitution of India to deploy armed forces there. We have specific legislation issued pursuant to that, and that legislation has not been questioned by UN Security Council. So therefore, this deployment is an act attributable to the Union of India. And any consequences which flow from that, the State of Union of India is to be held responsible. Then even if the Army's deployment is less or more, what eventually determines if a situation of a war crime has come into place is when you have a situation of a non-international armed conflict. And determination of a non-international armed conflict is either a domestic decision or it's an objective assessment that if a number of deployment is there, life conditions, use of weaponry, and so on and so forth. So if you use that lens in the test, then most of the international lawyers believe that it is a case of non-international armed conflict inside Jammu and Kashmir. And therefore, the violations will be viewed as war crimes.
Do we have time for one more question?
So you have a mind here.
Mike, you had a question.
Thank you so much.
Thank you very much. Obviously, the tribunals are a legal occasion created to thrash a proposition legalistically and they generate reports. And since the participants are well-recognized names, your question is interesting, that what gives the credibility? Normally the name behind the tribunal or the initiative itself gradually develops its own objective momentum, that globally people start attaching credibility to it. So, which means it could be an individual, it could be a group, it could be an organization or anybody. So the canvas is wide open. You don't have to focus on an individual to get a grant. You don't have to focus on a government. It could be a mix and match situation. And depending on what, it could be a resolution from a provincial assembly saying we want to set up something because we represent the people and there are a lot of voters in Punjab, in Sindh, or wherever. It could be the federal parliament, which can issue some sort of a resolution establishing this thing, that based on the plight and the concern of our constituents who vote for us, for them, Kashmir is a major issue. So therefore, we authorize setting up of some sort of a forum. So again, it's a very flexible option and it could be further deliberated upon as to how that can come up, and it could be attached with the name of someone who has international credibility. So all choices are open. Thank you.
Dr. Farhan, would you like to weigh in on the question? He can hear us, yes.
Assalamu alaikum, absolutely. Can you hear me?
We can, absolutely. Sorry.
I think it's a very important question, and I agree with what Sufi Saab has kind of explained about credibility is largely in the eye of the beholder. And this is one of the challenges that many Muslims throughout the world will face, is that many of the mainstream media outlets simply will not give you that venue. But we still need to fight ahead. We need to kind of push forward and bring aboard, which is what we tried to do by bringing Sheikh Dr. Umar Suleiman, Dalia Mugahid, and Jonathan Brown, Professor Anthony Cardi, and Tariq Shadkawi, Ed Mode. All of the professors that we had reached out to was precisely because we need to kind of create our own momentum. So while I understand the question and I see the point, you make yourself heard and you make yourself credible by the activities that you do. And rather than us focusing on whether someone else will give us credibility, I think that's a mistake. We need to establish it on our own. And so that's how I would respond to that question. Thank you.
Perfect.
Yeah, one quick point. You know, when it is kind of an alternative model as well, these public tribunals, to when you believe that there is apathy of international community and there is inaptitude of international courts to take up certain matters related to war crimes or crimes against humanity. So then, you know, these kind of public tribunals, they come into place for the voiceless to get heard. So this in itself is a symbolic thing which has great moral credibility in itself, that you are giving space to the voiceless who are not otherwise getting heard. And with this, I just like to add one quotation from Elie Wiesel, the one who was the survivor of the Holocaust, and who said that neutrality, it helps the oppressor, and silence, it encourages the tormentor. So, with this pretext in mind, you can understand that they have a moral credibility, and as Sufi Saab said, the people behind them, those like, he introduced the 15 people, dignitaries who were there. So they in itself become credible. So.
Thank you, Dr. Raja Kasir. I'd now like to invite our chair for this session, Ambassador Inamul Haq, to sum up the discourse from the seminar.
Bismillah ar-Rahman ar-Rahim. We are now coming to the conclusion of this seminar on the deliberations and conclusions of the Russell Tribunal on War Crimes in Indian illegally occupied Jammu and Kashmir. We have been privileged today to listen to the keynote speech by Mr. Ahmed Bilal Sufi, one of the eminent international law experts of Pakistan, who has represented Pakistan in many capacities abroad also, and who has worked on the issue of Jammu and Kashmir for many decades now, as well as to presentations by Mr. Farhan Mujahid Chak, Dr. Raja Kasir Ahmed, and Mr. Hassan Aslam Shad, followed by an interesting question and answer session. It would be difficult for me, if not impossible, to try to encompass the discussions that have been held today, and it would be futile also since you were all present here and you know what was said. What I would like to do in the next few minutes is to set the issue in perspective and see what is possible and what is not possible. Because sometimes we get carried away by emotions and we feel that the issue of Kashmir has started only yesterday, and we are the first to think about it, and people for the last 74 years have done no thinking on the issue or have not tried any avenues so far. The issue of Jammu and Kashmir is multidimensional and multifaceted. The first and the foremost issue, to my mind, is the inalienable right of the people of Jammu and Kashmir to self-determination. This right is enshrined in the Charter of the United Nations itself and cannot be denied to them under any pretext. This is a collective right. And as was pointed out during the question and answer session, the United Nations General Assembly every year adopts a resolution reaffirming the right of occupied people to self-determination. This is a right which has been denied to the Kashmiri people so far. Secondly, Kashmir is also an internationally recognized dispute between India and Pakistan, which has the potential of posing a threat to international peace and security. And that is why it was taken to the United Nations Security Council on the last day of 1947 by India under Chapter 6 of the United Nations Charter. It has been subject of more or less 18 UN Security Council and UNCIP resolutions, United Nations Commission for India and Pakistan resolutions. But all of those resolutions, as we know, remain unimplemented despite the efforts of the United Nations and the international community. Kashmir is also a remnant or of the process of decolonization. It is referred to as an unfinished agenda of the partition of British India, which created India and Pakistan, but left open the issue of Jammu and Kashmir. The Kashmiri struggle against Indian occupation is a national liberation struggle being waged by the people of Jammu and Kashmir, and it can under no circumstances be equated either with an effort at seceding from Indian territory, because it has never been a part of Indian territory under international law and under UN Security Council resolutions. And it cannot be equated to terrorism, as India often tries to do in international forums. It is in fact India which is guilty of state terrorism against the Kashmiri people. It is primarily an issue of, apart from being an issue of right to self-determination, an issue of the massive violations of the Kashmiri people who remain under illegal occupation of India by its military forces, which enjoy total impunity in their repressive actions against Kashmiri men, women, and children. These violations, as we know, have resulted in the killings of hundreds of thousands of Kashmiri people, injuries to many more, illegal imprisonment and torture, disappearances of thousands of Kashmiri youth, custodial killings, rape as a weapon of war, internal displacement of thousands, and the flight of hundreds of thousands from the territory as refugees. The destruction of the economy of Kashmir, the desecration of the religious places of Kashmiris, and there have been reports on that. Reports by the United Nations High Commissioner for Human Rights in 2018, first by Mr. Zaid Rad Al Hussain, who was the High Commissioner for Human Rights in 2018, and then in 2019 by Michelle Bachelet, who became the High Commissioner for Human Rights after being the President of Chile for quite some time. Unfortunately, there has been no third report, because the third report was contingent upon a visit by the representatives of the Human Rights Commissioner, both to Indian-occupied Kashmir and to Azad Jammu and Kashmir. The Indians refused that permission. Pakistan stated that it would allow the High Commissioner's team to visit Azad Jammu and Kashmir if India did so. So the visit did not take place, and a third report could not be issued. Many countries see Jammu and Kashmir also as a territorial dispute, which has resulted in conflicts between India and Pakistan in 1948, 47, 1965, 71, 84, and 1999. Man for man and kilometer for kilometer, today, Kashmir is the most heavily militarized territory in the entire world. And the military and paramilitary forces of India have committed war crimes, crimes against humanity, genocidal policies against the hapless people of occupied territories, and aggression against the Kashmiri people. Now, all of these four crimes are included in the mandate of the ICC, the International Criminal Court, which was established in 1998 to deal specifically with these crimes. But we have not been able to take this issue to the ICC. And the reason is that neither India nor Pakistan have become a party to the ICC. The only way to take an issue to the ICC is either when the country is a party to the ICC or the United Nations Security Council decides that an issue is worthy to be submitted to the ICC. It's unlikely that even if we ask the Security Council to do so, it will take or send the issue to the ICC for consideration, despite the fact that all of these crimes have been committed by India. And that is partly due to, or perhaps mainly due to, the weight that India today enjoys in international councils. India has emerged, whether we like it or not, as a very powerful country on the international stage. And very few countries in the world would like to take on India or confront India by adopting a pro-Pakistan or a pro-Kashmir attitude. Reference was made during the discussions by one of the distinguished speakers that if Pakistan could organize the ICFM in Afghanistan, why can it not get a resolution in the UN General Assembly for an advisory opinion by the ICJ? I would like to say that these are two different kettles of fish. The ICFM on Afghanistan was not called by Pakistan. It was called by Saudi Arabia. It was held in Pakistan because Pakistan requested the Kingdom of Saudi Arabia that the conference may be held in Pakistan. Secondly, it dealt with one specific issue. There was no territorial dispute. There was no right to self-determination involved. There were no countries which were opposed to offering humanitarian assistance to Afghanistan. The issue was only the grant of humanitarian assistance to the people of Afghanistan who were facing conditions of famine and starvation. And the international community, including the Western countries, joined as observers in the conference. When we take the issue to the General Assembly for even an advisory opinion of the ICJ, you can be sure that India will use all of its resources to oppose the resolution in the UN General Assembly. And you can never be sure that the majority of the UN General Assembly will support Pakistan's position for asking for an advisory opinion of the ICJ. We have had occasions in the past to move a resolution on Kashmir in the Human Rights Council, where our friends have told us not to push the resolution to a vote because we would not get many votes in support of a simple resolution on Kashmir. So when we make decisions as a government, we have to be mindful of the fact that we should not take any decisions which could rebound on us by failing. We cannot afford to fail on Kashmir. So it is better to be discreet and continue our efforts until we are sure that we can get something solid before advancing arguments of taking the issue to the ICJ. Now, the problem these days is the issue of the identity of the Kashmiri people, which is what I think the Russell Tribunal addressed in some ways, and we must continue to work that the world community recognizes that the Kashmiri people are being subjected to genocidal policies by destroying their identity. And this attack started a long time back, but it culminated in the actions of 5th of August 2019, which broke up the state of Jammu and Kashmir and took away its special status and created two union territories, that of Ladakh and Jammu and Kashmir to be ruled directly from New Delhi through a lieutenant governor. This illegal action clearly runs contrary to international law, to the UN Security Council resolutions, and it has been compounded by the removal of 35A of the Indian Constitution, which allows outsiders now to acquire land, property, jobs, and Kashmiri domicile. And we heard that millions of people have applied for, non-Kashmiris have applied for and are obtaining domicile for Kashmir, which could mean in a few years' time that within Kashmir itself, the Kashmiris would become a minority. So a major demographic change is being brought about deliberately by India to destroy the identity of the Kashmiri people and to destroy their majority in Jammu and Kashmir. And in this, India is pursuing the policies followed by Israel in the West Bank for a number of years. As we know, illegal settlements have proliferated in the West Bank. Israeli settlers are settling in territories of the Palestinians. And now Israel is even refusing to recognize the principle of two states in the area. So there is a creeping annexation going on. And same is now happening in Jammu and Kashmir, Indian-occupied Jammu and Kashmir. I will talk briefly of the principles that have been established, or guiding principles or stages of genocide. Gregory Stanston, who established the Genocide Watch, has listed the now generally accepted 10 stages of genocide in any given territory or area. I will just read them out, and you can, in fact, refer to Google if you are interested in learning more about it. This is the classifying the victim as them versus us. I was classifying it as the other. Symbols being forced on the local population, like the Germans did on Jews before the Second World War, making them a pariah group. Discrimination, ending civil rights of these groups through segregation, limiting them, denying them voting rights, dehumanization of the members of the pariah group. They're equated with animals, and we see that in India, even the Muslims of India are now being called as termites. And the Kashmiris obviously deserve even lesser epithets. Then they organize special army groups, or militias are organized, trained and armed to attack the victims. Hate groups are used to polarize and issue propaganda polarizing the different classes. There are planned mass killings, identifying victims, preparing lists, as happened in Gujarat when Modi was the chief minister of Gujarat. Separating victims on the basis of ethnicity or religion, persecuting them, and finally exterminating them. And the last is that the people who do this also deny that they have committed any crime whatsoever. Now, what are the solutions, possible solutions? There is a military solution, of course. If you are strong enough, you can militarily take over a territory, occupy it, and say that the issue is ended. Clearly, since India and Pakistan both are nuclear weapon states, and Pakistan is a smaller country, there is really no military solution to the issue of Jammu and Kashmir. Then there is possibly the political solution, which can come either through the United Nations or through some other organizations, or through bilateral negotiations, or through mediation, arbitration, or adjudication. But that involves the consent of both parties. India today refuses to discuss Kashmir with Pakistan. And that is why there is no dialogue going on between India and Pakistan for many years. Because we insist that Kashmir must be a part of the negotiations and discussions. Indians do not wish to discuss or touch upon Kashmir. They want to do cherry picking. They want to discuss only those subjects which are of interest to them. Recently, there were some indications that perhaps some in Pakistan were also coming around to the conclusion that Kashmir could be placed on the back burner, and we could talk of geoeconomics in which we could open trade relations with India. Indians would be only too happy to have a dialogue with Pakistan on trade relations. Because if you open trade with India today, you will be deindustrializing your country even further. You will have a major trade deficit of trade between India and Pakistan. Our industries cannot compete with India. So they will die out. They're already dying out because of the influx of Chinese electronics and other goods and industrial goods into Pakistan. Because they are not competitive. The Indian goods will be flooding Pakistan. You would be sending dollars out to India and you would be getting their goods. Your trade imbalance will grow further. You will need further loans from the international community and your economy will go under. So I do not see why at this stage, Pakistan should be prepared to put Kashmir on the back burner and start discussing trade with India, which will be a loss for Pakistan, not for India, which will be a major plus for India, because India will use that to tell the international community that, look, Pakistan has come round to our view that Kashmir is not important. They're discussing trade with us. They're opening up connectivity. They're opening up roads for our travel to Central Asia, because that will be one of the demands, that Pakistan should provide transit to Indian goods to Afghanistan, to Central Asia, to Europe and beyond. So we need to be extremely careful that we do not lose the emphasis on Kashmir by talking too much of geoeconomics and talking of regions progressing together. The political solution, to my mind, is not likely in the near future because the Indians are refusing to talk on Kashmir. Then we come to what Mr. Ahmed Bilal Sufi described as lawfare. In lawfare, there are two fundamental principles to my mind. One is possession is 9/10 of the law, and the other is might is right. That is what governs the international community. I'll give you an example. The United States is the most powerful country in the world. It has committed aggression practically everywhere since Second World War. I think 94 or more military interventions have been witnessed since Second World War by the United States in different forms. Has anybody ever taken the United States to any forum, either the United Nations or to the ICJ or to the ICC or to any other international forum? Nobody will. India is hoping to become one of the major powers of the world so that it also becomes so powerful that nobody can take it to any international forum to adjudicate on any disputes with other countries. It has already asserted its right of preemptive strikes against Pakistan because the United States can do so, so can India. And it tried to do it in Pulwama, but got a good reply from Pakistan and desisted from further aggression against Pakistan. Legally, we have a strong case, but will a legal decision force India even if it is taken in the first place. There is no international forum which will take a legal decision in this matter. The United Nations Security Council, as you know, met in camera, not as a UN Security Council body, but for informal consultations, more than 2 times, 3 times, I think, and did not even decide to issue a statement because there was no consensus in the UN Security Council. And the major powers, particularly the Western countries, the United States, France, United Kingdom, Russia even, did not wish this issue to be discussed in the UN Security Council. We have kept it on the agenda of the United Nations Security Council through persistent efforts, because there was an effort at one stage even to remove the issue of Jammu and Kashmir, the so-called India-Pakistan question, from the agenda of the UN Security Council itself. So we should know what our strengths are and what our weaknesses are. And where we are weak, we should bide our time, as Deng Xiaoping said, and build our strength before we jump into action. And finally, the fourth approach is the human rights approach, that we should approach the international community to protect the people of Jammu and Kashmir from the violation of their fundamental human rights by Indian military forces. We do that in the Human Rights Council. We do that wherever else we can. We can strengthen those efforts, and we should continue those efforts. But as was pointed out by Sufi Sahab, that does not necessarily mean that the UN Security Council resolutions on giving the Kashmiris the right to self-determination will still be implemented. I'm afraid I have not given you a very bright or very positive readout on what can happen and what cannot happen. But I thought that we must talk realistically of what is possible and what is not possible. I thank you for your patience.
Thank you, Ambassador Inam. I'd now like to invite Acting President IPRI, Brigadier Rashid Wali Janjua, for his vote of thanks.
Ambassador Inam, Ahmed Bilal Sufi Sahab, Dr. Kasir, and Mr. Farhan and Mr. Hassan Shah, if they are still on Zoom. I extend my thanks and special gratitude for a very, very absorbing and very engaging discussion. I think the more we discuss these issues, the more clearer we become in our thinking and approach, and reinvigoration of narrative and its reshaping is only possible after we carry out such activities with metronomical regularity, because this is how the issue gets embedded into your subconscious, and we go about with our proactive efforts. A very sobering discourse at the end in the summing up part by Ambassador Inam, who's always very perceptive with his insights, grounded in his decades of experience as a diplomat and both as an independent thinker. I think the most important takeaway from today's discourse is a renewed effort for properly resourcing this effort, as Bilal Sufi Saab said, that it cannot be a desultory effort which is from conference to conference. It needs proper resourcing, proper time frame and a structure. And I think we'll do our humble best to take this message to the policy makers to give traction to this idea. And I'm sure with these efforts, we'll continue highlighting the plight of Kashmiris, and definitely these efforts would, strike a resonant note, because the international community is also its response is changing. It's a changing world, as we say. And I'm sure with these efforts, we can give, some hope to Kashmiris, which we should keep doing. So in the end, thank you very much, and we'll give a token of our remembrance memento to the three speakers here. So the first one for Ambassador Inam, I think.
Ladies and gentlemen, this brings us to the end of today's seminar on debating the human rights violations and war crimes in Indian illegally occupied Jammu and Kashmir.